Welcome back to the Kruse Law YouTube channel. I want to discuss with you today driving prohibitions versus driving suspensions, and I'll give you some examples on this. So driving prohibitions occur under the criminal code, for example, an impaired driving conviction or a dangerous driving conviction, for example. So let's take impaired driving. So under the criminal code, on a first-time conviction for a DUI, that's an impaired driving charge, the judge has to take your license for a mandatory minimum 1 year. Now, they can take it longer if there's aggravating circumstances, but it's a mandatory minimum. For a second conviction, where the Crown relies on notice of the prior conviction, the judge has to take it for a mandatory minimum of 2 years up to 5 years. They prohibit you from driving. For a third conviction that you have, so it's you're completing guilty today and you have 2 priors, you're facing a mandatory minimum of 3 years up to life. Now, lifetime might occur, for example, when you have multiple priors, or dangerous driving causing death, in some cases impaired causing bodily harm. So the judge has discretion. It might be 5 years, it might be 8 years, but a mandatory minimum 3 years. Now, the ministry, what's a license suspension? Well, a license suspension is imposed under the Highway Traffic Act. The ministry is an administrative license suspension. They have a totally separate scheme, and sometimes it's difficult to understand. But what the ministry does, if it's a first-time DUI and the judge takes it for 1 year, the ministry has to take it for the same 1 year. That's a rule. And they run concurrently, meaning at the same time. Now, on a second offense within the previous 10 years, so if you plead guilty today and you've got a prior within 10 years, the ministry will take it for 3 years. So that might be 1 year longer than the judge. So you're serving 3 years. You got the judge's 2, and then the ministry tacks on the 3. So, you got that extra year. Now, this is where the kicker comes in. On a third offense, within 10 years, the ministry is going to take your license for life, reviewable after 10 years. On a fourth offense within 10 years, they're going to take it for life. You're gone. It's all over for you. You'll never drive again. So, there's similar concepts. It's prohibiting you from driving. The judge has discretion. There's mandatory minimums, and the judge can go higher. With the ministry, there is no discretion. There's very stipulated rules about how long they take. Sometimes the suspensions occur at the same time, for example, the 1 year. Sometimes the ministry suspension is longer than the judge's. Sometimes the judge's prohibition is longer than the ministry. It really depends. But the important thing to note, and I reviewed this in another video, you should look at that 10-year limitation period, because I just reviewed that very extensively. It's a very important point regarding lifetime. I talked about lifetime suspensions there. So there you have it. It's a quick primer on driving prohibitions under the criminal code versus license suspensions under the Highway Traffic Act. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.